Good morning, everyone. We'll get started in just a minute. Give folks a minute here to get here. Okay, good morning there. We're here with the method subgroup. I'll just go over a few things from last week. Again, the description of this subgroup is to place registrants on the registry, including the processes to challenge or petition for removal. Last week, we had discussion of an administrative process for off-ramping, the idea that there would be a review of other states. Also discussion of a specialized uniform court or administrative group similar to the tax court to review, that would include subject matter experts who would then review the requests for off-ramping. But that was sort of put on hold, further discussion pending a subgroup from Brian, Renee, and Stacy, and anyone else who wanted to be involved in looking at other states and their off-ramp processes. There was also some discussion about formal assessment of those not in prison. Would it serve a beneficial purpose if considering off-ramp for the approximately 50% who are not assigned a risk level? And some discussion of the access to the registry. Example was 667,000 times it was accessed in 2018. And for what purpose? Is it used to investigate an unknown perpetrator? Pretty much the idea that very few times is it used to investigate a sex crime. Most commonly, it is used to update information and check on compliance with the registry. That's what most of those touches into the system do. So, was there anything you wanted to cover before we start, Olivia?
No, thank you.
Okay, and then Angie and Stacy. I guess you are the two chairs here. Did you have anything to start with? Angie.
I was not here for the last meeting of this group and wasn't part of the subgroup. But I just wanted to ask Stacy, and maybe this is something that'll be covered in the meeting, but I talked yesterday at the meeting, Stacy, that you weren't present for about, I may have access to a law clerk. So if there's anything that we still need as far as comparing anything for any of our groups, maybe we can get that identified and I can get help if that's still needed at this point. I know you sent a website to Brian that he shared, and that seems to have a lot of good comparative information, but I just don't know if you need more nitty gritty stuff. So I just wanted to put that out there so you know I know I emailed about that too. So
Yeah, thank you. I think a law clerk is amazing. So let's think about how we can use that person. I think we will be able to. We just need to come up with a defined research project.
okay.
And do we want to add that to the agenda then for the chairs meeting so that we can kind of talk through that?
That's a good idea, Olivia. Why don't you do that?
Okay, anything else to start us out, Stacy?
I don't have anything else at this point.
So Renee and Brian, were you ready to report anything that you had? Renee? Whoops.
Yeah, so something that came out of our subgroup was that Brian, Stacy, and I were going to take a look at the website of the 50 states and who's eligible for off-ramping, so to say. So we each did kind of like a sample of that, and I don't know if it's timely to start with that here right now with what I found with the sample that I took, or Stacy, I guess I follow your lead with how you'd like to go forward with this.
Yeah, so just so the group knows what we looked at, we divided, Brian, Renee, and I divided up this 50 state survey. I would look at juveniles and how states are off-ramping juveniles. And then Renee and Brian split up some of the states. Given the number of states, it's a lot of work to go through each state. So I'll just say, Renee and Brian, for my part, I just did a handful of states, and I have just a quick deck that I can share, which is pretty synthesized. And we can go over, maybe just what we're finding. There's a huge variety, as you would expect. So I think it's a good time to do that. I do need to say, I need to pull off early today because I have a deposition that's actually going on right now that I would like to be in attendance to. I'm not obviously taking it, but I need to observe it. So I need to pull off early.
And it's Stacy, as you provide that or show that to us, I would just say that in the states that I pulled, there were variations, but there were also some very common themes that I saw among the different states. So at some point I can certainly share that information too. And Brian and I took the adults. So Brian did the first half of the alphabet, so to say, and I took the last.
Yeah, so, well, I could start by sharing mine if you guys are okay with that.
Okay. Yep. Yeah.
I guess I'll just share my screen. So I only have one screen today, so I can't see.
Yeah, we're not seeing your Sherry.
I know, not yet. Let's see.
Do you want to send it to either Mark or I and we can share it to the group?
Oh, that's a good idea.
And then you can see us and we'll display.
Yeah, that's actually a super idea. Why don't it's a PowerPoint. I'll just send it to both of you and you guys can decide. And this is really it's really quick and dirty. I didn't spend as much time on it as I would like, which is, I think, where that law clerk could come in. But it gives us a flavor of what's happening.
Okay. I have it here.
Okay,
Okay, great. So one of the things, of course, we found, and we already knew this, is that, some states don't require juveniles to register. And then what I found was some states require registration. So just to back up, there may be some information in looking at this off-ramp to understand when juveniles are required to register. So in some states, they require juveniles to register, but only in certain circumstances, like if it was a violent crime. So that was kind of interesting to just see, that as we talk about in the crime subgroup, whether juveniles should be on the registry, maybe it's just not a black or white issue, maybe it's, some juveniles absolutely, others not, or at the time of a sentencing, that there can be, a request to not be on the registry. So that's what I saw in some of this, work. Anyway, I started with the A's as a logical place to begin with. So just really quick here, this was in Alabama, they set up a petition to the sentencing court at sentencing or after sentencing. And then it's certain eligible offenses may petition for relief. And I think I don't know if I fleshed out which offenses, but that's super important to know as we move forward, is what offenses are eligible for relief and what isn't. And then they also had a mechanism for lifetime juvenile registrants. So they were required to register for lifetime, and that at some point after 25 years, they could petition off. And this gets into the mechanics here. The petition is actually filed in juvenile court of the county that they were adjudicated delinquent. And if they're out of state, the county where the juvenile, who now may be an adult, the wording of the statute was kind of funny, but they may be an adult now where they reside. It's served on the prosecutor, just prosecutors, and then local law enforcement where the registrant resides. You can move to the next slide, Mark. Let's see. The contents, just kind of basic documentation to show where they are at in their life in terms of what they've completed. I think that's fairly self-explanatory. People can just look at that quick. You can go to the next one. Okay, so here, this was kind of interesting. The prosecutor is to make a reasonable effort to notify the victim, dates and times of the hearing. So in a lifetime registrant situation, maybe the victim can't be found, or maybe that, good. We can talk about whether victim notification is important. In Alabama, they obviously felt it was. So, so that the question is, should a victim be notified? And if it's that many years after, the prosecutor just needs to make a reasonable effort. The hearing. Oh, there's always a hearing, sorry. And then these are the 7 factors that the court is to consider. The recommendation from the PO officer, Renee and Brian, you and I have talked about that. Recommendation from an SO treatment provider. I find this kind of interesting because if after 25 years, if you're dealing with someone who's been on for 25 plus, and it was a juvenile adjudication, that was a long time ago, presumably, that they may have finished sex offender treatment. So I'm not sure how that works. Just kind of interesting. A recommendation from the prosecuting attorney, victim testimony or parents of the victim, guardians of the victim, the facts of the offense, any criminal activity before or after the sex offense, how is the registrant doing life-wise, employment and housing, considering the protection of society and other factors relevant, whatever those might be. You can go to the next one.
Renee, did you have a question at this point?
Yeah, I just have a comment. So Stacy had said that on the sex offender treatment provider, I anticipate this is probably how this looks, is that so when in the beginning, when a pre-sentence investigation or disposition report is being completed, a psychosexual is completed. Commonly along with that is a risk assessment. So in my opinion, it doesn't, and actually the treatment provider may no longer even exist, but they would go to someone that specializes with this, provide that kind of a report, and then that
Okay.
recommendation. So that's how I'm anticipating that will be done. I think we will get caught up with these individuals is the money to pay for that.
Yeah,
Yeah.
it's expensive to get those evaluations. Yeah. Okay. Yeah, so then there's a disparity, right, in who gets to get off. Yeah.
Yep. Exactly.
Well, that's good to know. And then they have a clear and convincing standard that the person is rehabilitated and they're not going to pose a threat. And then they can, if denied, petition again after 12 months. So that's Alabama. Alaska has no registration for juvenile offenses. And we know that there's a handful of states or more than a handful of states that don't even have it. Here, just a note about Alaska in 2019, the Alaska Supreme Court held that the statute was unconstitutional because it didn't provide a process for a procedure to let them establish that they don't pose a threat to the public and petition off. So now Alaska has that process in place. Arizona, this was interesting. Arizona, a petition is available for an offense that's committed under the age of 18. It's also discretionary termination by the court if once successful completion of probation. So however long that probationary period is, they can petition then. For a conviction under 18, may also petition for termination at annual probation hearing until they're 22. And then what I did find in just kind of ripping through the states quickly is there's a lot of petitions off for the statutory rape within certain age differences. So that's what they did here in Arizona is under 22 with a probation sentence where the victim was between 15 and 17. So, and then they would petition on completion of their probation. You can go to the next slide, Mark. Other conditions that bear, no other related or felony, related offenses or felony offenses, and no determination, it's kind of weird, worded interestingly, no determination that probable cause exists to believe the person is a sexually violent person. And then the petition would be denied if it's in the best interest to protect public safety. That's Arizona. Iowa, juvenile court in Iowa. So I did that. I did those 3 A's. And then I just kind of looked at our surrounding states. Juvenile court may waive registration requirement in most instances. I think there's some juvenile offenses that they would not have that, and they list them out. Prior to discharge, most juveniles may move for a modification or suspension upon a showing of good cause. Again, I didn't flesh out the statute and what that all means, but just as a concept and as a policy in Iowa, that's what they do. Wisconsin, similarly, certain juvenile registrants where there was not an offense, where the offense did not involve violence or violent intercourse, actually, may petition for relief at any time under 25 years old. And then I don't know if this has any applicability here, but if there was an expungement of certain invasion of privacy convictions, upon completion of that dispositional order, the registration obligation just ends. So it's just done. I don't know if that has any applicability here. I'm just not as plugged in on the juvenile stuff here in Minnesota. South Dakota, tier 1 juvenile registration. So South Dakota has a tiering, which I didn't have a chance to really dig into, but they tier, maybe it's levels, I'm not sure, like our levels, but tier 1, convicted of certain age-based offenses. So, oops, shoot, excuse me. Can you see just my screen and not my emails coming through now?
Just the screen.
Okay. So age-based offenses, after 5 years, they can petition. So on for 5, and then if there was a statutory offense, then they would be allowed to. And then if it's a suspended adjudication, once that suspension is done, or that time period is done, then the termination of registration also ends. So that was kind of interesting. What do we have next? We did Michigan. Those convicted of certain consensual youthful offenses may petition to terminate at any time. So these age-related offenses, the statutory offenses, can do it at any time. And then tier 3, again, a tiering system. I don't know if that's level system like our level system, but after 25 years, I think that was similar to Alabama.
Yeah, and Michigan has the federal style tiering.
Okay,
Based on convictions,
okay,
not on risk.
okay.
So does South Dakota then too, Mark? They reference that tier on there as well.
Yeah,
Yeah.
that makes sense. Okay, thanks. What else do I have? I think I have, do I have anything else or is that the end? Oh, so this was I did flesh out, I just pulled the statutory language, it's kind of dense, but this is how they broke down how a juvenile could get off. So again, we have the consensual act between the petitioner and the victim. And then here are the age breakouts. So victim was 13 years of age or older, but less than 16, and the petitioner is not more than 4. And so they just break it out. We don't need to go through all of those, but those individuals, those kids would be available to put forth a petition. So I thought that was kind of interesting and helpful to look at. And, obviously that's just a really small handful of states. That's what I got, Renee and Brian.
Well, I could jump in. I think Renee did a little deeper dive than I did. I did kind of the 30,000 foot flyover version down and dirty like Stacy did. I didn't even have a nice PowerPoint. I just kind of actually cut and pasted some information from that link into a Word document. I can share that, but I'll be reading it because it's pretty small. People probably won't be able to see it too much. People see that now?
Yes.
You can't probably read it, but you can see it. So what I did is I went A through M and just kind of took a snapshot of 6 different states from the adult standpoint in terms of relief from registration. I think that the law clerk idea, as Stacy and Angie had mentioned, would be really helpful in going through this. There's going to be a question of what does this mean? What are less serious offenses? What is it on a state by state? Yeah.
I'm so sorry to interrupt you. Can you zoom in just a little bit?
Let me see here if I can move this around.
It's at the bottom, Brian. There's that little 100% at the very bottom right-hand corner, that little go
Oh, there
over.
we go.
Yeah, that little thing you can.
Hello, there we go. How's
There we
that?
go.
Oh, perfect.
Perfect.
Thank you.
So now I can, there we go. All right, let me move this back out of my way. All right, so I did, started with Alaska, and just the top there is just what the registration timeline or is for Alaska. So lifetime for recidivists and aggravated offenses. Again, we don't know what aggravated offenses means in Alaska. Somebody looking into that down the
Yep.
line would be great. And then 15 years for all others. Stacy mentioned this. In 2019, the Alaska Supreme Court held that a SORA violates due process by requiring all sex offenders to register without providing a procedure for them to establish they don't represent a threat to the public. So the person can file a civil action in Superior Court in which they're permitted to attempt to prove that they no longer pose a risk for the public that justifies continued registration. If they prevail, they're relieved of registration. Jump in here, Stacy, if you want at any point.
Oh, I was just.
Angie? Oh, did Angie have a question or?
Well, I just was gonna point out, I think it's been brought up a little bit before, that Alaska and some other states have their community notification in their registration statute. So I think that probably affects that decision. From my recollection of it, is because it's a community notification statute in addition to registration. So I just wanted to say that we need to be cognizant that we are not we're not dealing with community notification in our statute.
Sure. Okay.
And Stacy, did you have a?
Yeah, I'm
Sure.
actually, I know the attorney that litigates all their registry cases in Alaska. And so he's just a resource in terms of, kind of how they are petitioning now. So that's just a resource that's out there.
Okay. So that's Alaska. California, they have in 2021 adopted the 3-tier system, 10, 20, and lifetime registration. Until January 1st of 2021, a certificate of rehabilitation relieved the duty to register for certain less serious offenses. Again, didn't delve into what that necessarily means. What's certificate of rehabilitation? What are less serious according to their penal code? And more serious offenses, duty to register relieved only by the pardon. Then effective this year, people in tiers 2 and 3 of the new sex offense registration structure may seek relief from Superior Court, where they're registered after a minimum period of registration. Again, I think I'm not sure if this is the federal tiers. I'm assuming it is based on SORNA. Delaware, again, with the tiers, assuming they're SORNA related, nothing related to risk. It's all just about the conviction in terms of what places you had tier 1, 2, or 3. Tier 3 being apparently seen as the most serious. Lifetime registration, tier 2, 25 years, and tier 1, 15 years. So tier 2 and 3 misdemeanor offenses, where the victim was not under 13, if the defendant was 18 or older at the time of commission, may petition the Superior Court for relief immediately. So again, maybe more of that statutory type offense. Tier 1 may petition the court for relief 10 years from the day of the last level 4 or 5 sentence, or from the date of sentencing. Tier 2 and 3 petition for redesignation and eventually reach tier 1, although certain waiting periods and eligibility criteria apply. Georgia, they have lifetime registration for all certain less violent offenses. Again, we don't know what that means in Georgia at this point. May petition court for relief from registration, residency, and employment restrictions 10 years after the completion of sentence. Such persons with risk level 1 risk assessment may petition for relief at any time. It just talks about non-sexual kidnapping of a minor, physically incapacitated residents can petition immediately as well. Illinois, no specific provision for termination, found that in several states that in sort of the A through M category. But the registration is lifetime or 10 years, depending on the offense, SVP status, sexually violent predator status, or recidivist status. And then Massachusetts, lifetime or 20 years, depending on the offense, SVP status, or recidivist status. They have 20-year registrants may petition the Sex Offender Registry Board for termination after 10 years. And I looked up the Sex Offender Registry Board. It looks like registration and notification classification processes are all combined in Massachusetts in one agency or under this board. And I actually downloaded a document. It's like a 40-page document, just describes those processes and, kind of their relief. A little bit more, it says, in terms of Massachusetts, motion for relief from registration obligation prior to final classification. It gets into some of the weeds a little bit more here, but I can share that document with Mark and Olivia, and if people want to read it further, breaks that down a little bit more. But again, quick snapshot of a few of the states that I looked at, and Renee can jump in, I guess, now.
Oh, here. There you go.
I was just gonna say, Brian, mine is very high level too, and I did not create a document because after we had talked yesterday or emailed yesterday, knowing that there was a law clerk that possibly would be available to us, I chose not to create the document, but I certainly can do that if people would like to see that. So.
Oh, no problem at all. Again, mine was cutting, pasting. It was not super high level stuff. Somebody else can really do a fancy in-depth job.
So before we clarified exactly what we were doing, I was starting with the N's. So I have like 6 N's and 1 O, just so you're aware of that. But I started out and I thought it was really interesting that for Nebraska, it was life 25 and 15 years. They petitioned the state patrol. I thought that was like super interesting. They petitioned the state patrol and I thought, well, how does that work? But what I found out of the 7 is 1 petition the state patrol. New Mexico, there was no process, and that all the other states were petitioning the court. So I thought that was, these are some of the common themes that I was seeing. So it's interesting too, that if they're a 15-year registrant, after 10 years, they can file for that relief in the state of Nebraska. So I thought that was interesting. And then when you go into criminal history and eligibility, it's no further sex offense that they've had, and no felony and no violations while they were on the length of time under supervision. So I thought that was interesting. Nevada was the same, life 25, 15 years, but they did petition to the courts. It was only tier 1 that were eligible to petition to the court. However, at age 21, they could have a hearing for consideration. And that was in the juvenile area. But again, consistently with Nebraska, it was no further sex offenses, no violation while they were under supervision. So, and they take into consideration, again, the criminal history, and what that looks like for them. Those 2 states were really kind of vague for considerations, where some of the other states I saw went into more detail, such as what we've talked about, the risk assessment, showing low risk to reoffend, community safety, those kind of things that, successful completion of sex offender treatment, those kind of considerations. I see Stacy has her hand up.
Yeah, so my question is, when you say no violations, you reference that, do you know what that means when they
Yep.
say, is it no violations of any, like no criminal activity whatsoever, or is it no violations of something else?
No violations while they're under supervision. So no probation violations while they're under supervision.
All right.
Yep. So they have to have a perfect clean record in order to move through that, which I thought was super interesting.
Do they have to have a clean criminal record? So if they got like I don't know, let's just say a disorderly conduct or, something, do you know if that would disqualify them from the petition?
I did not dig into that deeper. So, but I know in the ones that I'll get to, like the state of Oregon, they could not have a previous crim sex offense.
Right.
So you're talking about a couple of different things. Do they have a prior record? They pick up anything while they were on for that offense. So New Hampshire, they had tier 2 and tier 3. I thought it was interesting because I didn't see, the only thing I saw in respect to tier 1 was after 15 years, the tiers 2 could petition for relief to the court. Tier 1 was after 5 years, which I thought was super interesting. So, and with that, it was taken into consideration their criminal history and then consistently what I saw among many of the states is after 15 years, they could petition the court. And then I had New Jersey and their lifetime registrants. They could petition the court after 15 years. And then it was interesting, it said after 15 years and no risk. And it went into a little bit more detail, but it's again, I think if we chose to push this forward, we would need to define what we meant by that, as far as the no risk or the very low risk to reoffend. So I thought that was interesting. New Mexico, they're life or 10 years, and there's no relief. New York, they have similar to, I believe, what our system would be. They talked about level 2s and level 3s, and life in 20 years for registration. For early termination or the off-ramping, level 2s, and they cannot be considered as predatory or sexually violent. And they, again, would petition the court. And then the other considerations that I pulled up was after 15 years, they could petition the court. And again, they would have to show that they are at low risk. And I didn't go into the details of what that would be. And then Oregon was life. And they are not ever eligible if they're found to be sexually violent and dangerous, certified or classified as a level 3, guilty of, and they have a list of serious offenses. So what I'm thinking is that what might be like our Crim Sex 1 might be in that list of those serious offenses that maybe they could not be granted permission to file for that petition for relief. And then they went into misdemeanor and class C's. And I did not go into the definition of that, but it really ranked, I was very curious that they could petition to the court 10 years after they were successfully completed probation supervision. So I thought there too, as you were talking about, Stacy, that length of time from discharge and then 10 years thereafter, it's just so long. It's interesting. It would be interesting to know how they came to that decision, if there was some research behind that supported that. And then their level 1, they can petition the court after 5 years of being a level 1. And then they took into consideration this, which I did like this about the adults here. So certain clients, if they were less than 5 years older than the victim and had no prior sex offenses. So that's that statutory situation that I liked seeing that there, because those are some of the circumstances and situation that I've shared before where they moved on with their life, they've married, they're employed, that kind of thing. And level 1s were eligible. And again, the misdemeanor class C felonies were also eligible. And they went into a longer list of of what they had to bring to the table. So clear and convincing evidence. It'd be interesting to see how they came up, how they would prove that. They're a level 1, low risk and unlikely to reoffend, and does not pose a risk to public safety. So they were a little more prescriptive of what they requested. That's what I have.
Okay. So we should give Karen an hour to prepare the response from the courts to probably this likely idea that it's going to the courts. I'm just kidding, Karen. Yes, Karen, you're up.
Well, just since you called on me. Yeah, I mean, I'm taking that all as a very generic reference right now, because I know there's been a lot of discussion of whether you really want to see it as a petition to just like the sentencing court, or whether you're still envisioning some kind of a panel like the sex offender panel or something. So I'm going to withhold having any reaction until you hone in more on what group or individual these petitions would be directed to.
Good idea.
Yeah, I thought so.
Stacy.
Yeah, so it was interesting to see that they are doing it mostly in court. For juveniles, I think it My opinion is for juveniles, there was that one state that said at the time of sentencing or any time after, they could petition to be discharged from their registration obligations. It seems closer in time. I continue to favor this idea that Renee and Brian and I came up with, which was more of a panel with that specialty group. However, I can also see that there's a couple ideas. If it is the court, you're kind of just giving the court everything that would be hopefully drawing from those various disciplines. We talked about I'm just trying to remember our list, but it was a law enforcement person, it was a psychologist, it was a victim, advocate. And so there was that on the panel. It seems like it has the same effect because you get all those disciplines on a panel to make the decision. Whereas with the court idea, you're kind of packaging it all up and giving it to the court. I don't know which one's better. I don't know if these states that have this court process considered, a panel like we do with our leveling here. The state patrol, that's just bizarro to me. I'm not sure what's going on there. That'd be interesting to find out what the state patrol has. I mean, I suppose maybe it makes sense in terms of tracking people, I don't know. And then there was one state, Renee, that you said there was some sort of board. But I think we should continue to, my recommendation or I favor continuing to look at a panel that has those disciplines, because I think that's going to be a more, at least, less disparate impact on maybe people who can afford to petition and give greater access. And you would hope actually make better decisions, right? Like make more informed decisions because you have all that discipline right there, discussing and deliberating.
Okay. Patty.
I believe that in some states, the state patrol is kind of like their central crime, like the BCA. And it sounds different to us, but that's who houses their state crime unit.
Yeah, yep, that is accurate. So like in California, the state patrol would be very similar to
New Jersey. New Jersey might
yeah. So it may very well be that their state patrol is their registration hub, as well as all of those other services, evidence, DNA, those kinds of things.
Brian.
Yeah, I do, again, just wanted to support the idea Stacy brought up, and we're talking about the administrative panel and that group as well. We just need to make sure whatever we do is risk-based, not, a lot of this tier talk is all based on conviction. That's somebody can have an offense from 40 years ago that fits into that tier 3 category, and they're designated tier 3, and then they're subject to, a lot more check-ins or, registration compliance checks and other factors, when it really could be, they could be very low risk. They haven't reoffended in 30 or 40 years, maybe. Conversely, you can have a guy maybe designated tier 1 that has some concerning high risk behavior going on, that, an administrative panel, a group of experts can see what's going on currently right now, do the risk assessment piece, actuarial, and just get an overall look at the individual to make like Stacy said, more informed decision. So.
Renee.
Yeah, I would just, Brian, Stacy and I talked about this at length. We actually talked about a supervisor too, that possibly supervisors, agents that supervise clients that have been convicted of a sex offense. And of course, a probation officer also being on the panel. With that being said, I can definitely attest to how many times I had to go back in chambers to explain to a judge the dynamics of like the sex offense, to explain to a judge, you know, for what the registration requirements are. To, you know what I, so, and what kind of treatment I perhaps was recommending and why, based on the dynamics of the offending behavior. So unless you have a designated judge or panel of judges, whatever, that are well educated and versed in this population, it's going to be, people will probably look for judges that are likely to provide grant petitions. I think the panel I'm not saying that judges aren't objective. I'm just saying it's the knowledge base with that and the expertise of the panel that I've been advocating from the beginning.
Representative O'Neill.
Thank you. So in your research, this is something really important to the legislature to understand. And I know we're not quite in the weeds, but in your research, if there's an administrative panel, does the law say exactly how many? And if so, how many are you seeing? Is it a panel of 3, 5, 10? You know, how big is this panel? And then another really important factor that we'll need to know is if they're going to vote, which I'm assuming there has to be some sort of a vote, just like some of our the panels to release somebody from prison, you know, the parole boards and different things. Is it unanimous vote, a supermajority vote, or a majority vote?
Make note of those questions for the further investigation.
Yeah, because if we don't have them, we'll create something, and maybe that's maybe not the best answer, but I think that's a point. If this is what we're going to do, obviously, if it's a judge, the judge gets to decide. But if it's an administrative panel, then we'll need to know those particulars.
Okay, Renee.
Yep, we actually came up with 6 panelists that we thought would be good. And I didn't write them down, Stacey, because I had thought you were going to, but the probation officer, a therapist, law enforcement, somebody from a victim advocate, a supervisor over agents who supervise this population, and I forget the 6th person. And we did not talk about whether it needed to be unanimous or not. We didn't talk about that voting piece of it.
I'm so sorry, Patty.
Go ahead, Olivia.
I'm sorry, we still can't raise our hands because technology. But my only thought would be that there could be a lot of tie votes in the number 6, and just to be aware of that. I don't necessarily know that we as the BCA would have an opinion on any of that, but it is something that we have seen in those even numbered panels before that adds a little bit of difficulty administratively.
Patty.
I just have this nagging thought, and I thought I would share it. I like that some of the states make 21 a point in time where things can change. But also, I've been talking for this whole time about the age of 25 for brain development. And I know this is the crazy thought, but for juveniles, most of their victims are someone known to them. I don't know that, I think it raises a different category of risk if a juvenile actually offends a stranger or randomly, like the story that she shared yesterday. I don't remember the person sharing. So, you know, that there's categories, but this is my question. In the Department of Corrections, I know that people are sentenced to 20 years, but they seldom serve 20 years, right? They go, I don't know, that they used to call it good behavior. They're released isn't that true? Like Danny Heinrich was sentenced to 20 years, but he probably would serve like 17 or 18. Am I making that up?
I think, Brian, you can.
Yeah, so in state corrections in Minnesota, it's a determinate sentence. So if they get a 15-year sentence, they'll do 10 years in prison for sure.
Unless they
there's no good time consideration, so they won't get out earlier. They can actually lose time
right
from discipline and things like that. So they could extend that time based on what they do in prison, but they can't get out early. There's no parole board type situation. It's you do 2/3 of that sentence. Now, in terms of Danny Heinrich, and I think the federal system has different regulations. I'm not exactly aware of.
But it's still, they
how
don't
those
serve,
specific-
they seldom serve the full
Well,
sentence.
Yeah, I don't know about the feds, I guess, but not, yeah, so the Minnesota, it'll be that final third on supervised release. Although most guys who've committed, men and women who've committed sex offenses get an additional 10-year conditional release, sort of over and above that, that final third sentence, but.
Yeah. So my question is, with juveniles, you know, could we have the motivation that if there are no other reoffenses and that they have these things, that they could appeal at age 21 or at age 25 if they are put on at all. My thought is that they don't really belong on a registry, but for some of the more of egregious offenses, that they could, when at age 25 is what I'm recommending, because that's the brain research thing that says that now they have no excuse. They've got full brain cognizance. So I was just trying to think of a model that we already have in Minnesota, determinant registry, determinant sentence. It's just I guess I'm looking for a motivation for all sex offenders to change their behavior and not do anything to cause it to get extended, but more of a motivation for them to get actual opportunities to get off. I'm looking for the motivation piece.
So,
Brian.
yeah, I was just going to comment on the end of confinement review committee. Most people are aware of this already, but we have 5 members, 5 voting members, and it's a majority vote decision that assigns the risk level at the ECRC meeting. So again, that tie, don't have to worry about the tie situation there for that reason. I don't know if that's why they went with 5 or what, but it's helpful in that regard for sure.
Representative O'Neill.
Thanks. So I also want to talk a little bit about the juveniles, and we have, whether it be an informal system or a formalized system, I'm not really sure, but we have the stay of adjudication that is available for juveniles. And if we want to make that more prominent, more formal, however you want to put it, and extend it from a 12-month to an 18-month so they can complete treatment appropriately, I think that's probably the best course, since we already have that established in our statutes. And there should not be juveniles on the system. You know, if you look at the juveniles that are on there now, so there's 38 out of a little over 18,000. And Josh was very kind to tell us what those juveniles had done and had committed. Now I know there are several that were convicted as juvenile and that they've obviously now are long into adulthood, but you know, we can't make anything retroactive, but we could do an off-ramp with conditions. So I would just suggest that I think that if you want to formalize the stay of adjudication process, the prosecutor from, was it Teresa, I think, from Hennepin County, was saying that's what they do, and they felt that was very creative. But I got to tell you, I mean, it's done other places. Wright County's been doing it for many years, and Wright County didn't make it out to be some secret process or something, that this is some creative way we figured out how to get around it. That's not how it was explained to me at all. So I would say we should have some conversation about that with the juveniles. And it seems like we've been very careful of which juveniles we've actually put on it. Maybe not 10 years ago or 20 years ago, but as of recently. So, and then also I was wondering if Renee could tell me the associate probation's officer was 1, and I missed number 2, and she was going to come back with number 6. So also I would say an even number is a bad idea on a panel. You need an odd number unless you're going to have a unanimous vote. So, and the more you have on there, well, I say the less you have on there, if there's only 3, like when we've got so the governor and the Supreme Court Justice, Chief Justice, and I'm trying to think of the 3rd person, but I think it was Harrington, maybe. They all had to vote yes. I think that was their, I'm sorry, I'm rambling. So anyway, if you have a panel of 3, it should be unanimous. A panel of 5, you could do a super majority. A panel of 7, you could do a simple majority. but you definitely do not want a panel of 6.
Stacy.
So that's super helpful since we proposed or we came up with the idea of a panel of 6. It's good to know. But just my notes reflect that we, would have a chair that might be a supervisor. And then a psychologist to do the risk assessment, law enforcement, probation or parole, someone retired. And then 1, 2, 3, a therapist, and then a victim services, maybe out of the DOC. So that's the 6. We came up with the chair idea as a district supervising person, as that 6th person. So we can talk about that, Brian and Renee, about what the makeup of a panel could look like.
Sure. And then criteria for relief.
Oh, yeah. So on the ECRC, yeah, and then the criteria, yeah, I think those are pretty fleshed out and pretty simple to pull from other statutes. So the ECRC has the chair, psychologist, victim services, local law enforcement, and the case manager of the incarcerated person. Yeah, so that's where we look to model off this POR panel. So, I mean, and I just wanted to comment on the juvenile piece, that Patty had raised. A lot of the states are, the petition age is 22. I don't know where we're going to come out on getting juveniles off the registry. I don't know. I wasn't in yesterday's crime subgroup, but, I mean, my hope is that we can get at least some kids off the registry. Not knowing where we are in that kind of process wise and deliberation wise, it seems that, the off-ramp is a good mechanism to, if we say, like, as a policy matter, no, we want kids, we want these juveniles, this certain subgroup of juveniles who have been adjudicated to be on the registry, well, then let's the off-ramp seems especially important to support their rehabilitation and full integration. And I know that 25 is, that 18 to 25 is that when that full prefrontal cortex is developing. I would be curious to try to understand a little bit more why a lot of states are at 22. Like, what's that if you're college bound, that's oftentimes you're done with college and maybe entering the workforce. Maybe that's it. I don't know why they were looking at that 21, 22 age. So something for the law clerk.
Okay. Anything else here? Oh, Patty, you're on mute.
Yeah, sorry. It's just a question. So do we need to, are we in agreement that we're going to build an off-ramp, or, do we need to take some kind of vote with this committee, or I like, even for adults, I really think that we need to have this process, because it's, to me, that motivation piece of doing good and causing no further harm. And do we have, is that an agreed upon thing with everybody? Did we
So
vote on that, or
from
do we-
the
Go
From the
ahead.
state agency perspective, we're gonna need to see the full off-ramp and what that looks like in order to give any kind of vote on anything. So we can't have a perspective on anything until that point in time, I'm sorry.
That's okay. I love this idea and I think it's a needed next step, but what I'm asking is that in agreement with everyone else?
Brian,
I was just gonna ask, I forgot the polls. Did we do official polls for this? I missed one poll that was kind of an unofficial poll. But then was there an official poll related to the off-ramp and what were the results there?
there were 6 people who responded to just a Zoom poll. 4 of 6 supported off-ramp for 10-year registration. 4 of 6 opposed an off-ramp for lifetime registration. I don't know if any of that has changed, but it was a limited number.
Okay, and that was, yeah, I missed that group. I would support 10-year and lifetime off-ramping if I voted now, but yeah, so just to follow up on that, I think the off-ramp idea is much needed. As Stacy said, if we are saying, especially juveniles or anyone is required to register on the front end, there should be a mechanism for reassessment or evaluation at some point if they've proven they're doing well and have lowered their risk to the community, I think.
Yeah, and I think this group or the entire group does need to have some kind of a specific concept to work from, because I think the group is just at the idea that yes, an off-ramp may be possible, but yes, legitimate questions. What would it specifically look like? So Stacy.
Yeah, I'll just make one final comment. My understanding was that the poll results were 4 to 6 for the 10-year and 2 to 6 for the lifetime. And I was one of the 2 that favored lifetime. As we can see from the statutes that we've looked at, lifetime is really a common one for people to come off the registry or petition to remove. And so I think that if we're looking to other states and what they're doing, that's one that many states have is for lifetime. I think that, obviously people are going to need to look at the statute or the proposed off-ramp and the language and what that all looks like in order to say, yeah, this looks good. I think for our work for the subgroup, given the results of so it was a small group of people that voted, but that my understanding is that there is favoring of considering an off-ramp. And so when we get to the point that we research this, we draw it up, and then, it's probably going to work itself out like many of the issues that we've considered as a majority and minority report to the legislature.
Representative O'Neill.
So I don't think we have anybody from law enforcement with us today. It looks like Sheriff Heck is not here. I think that they would be a invaluable part of this conversation. And now my question is also, do we have anybody from the County Attorneys Association on the panel today?
No.
No, we don't have either. So those are 2 really key people that we need to pull into this conversation. And unfortunately, they're not here for one reason or another. But I also have a question for the county attorneys, which of course they're not here, but I think since we had that conversation in the previous subgroup about, I think it was Teresa from the Hennepin County Attorney's Office prosecutor. She was a prosecutor. And she made it sound like the juvenile state of adjudication was some workaround and kind of a secret process and all of that. And I'd like to hear from the County Attorneys Association, because my understanding is it's much more widely used than Hennepin seems to think. So I think that we need to hear from them as far as if it is widely used, if not, why not? Is that something that we could tweak to make more available? So it seems like a very good process.
Yeah, and in an earlier meeting, Shane Baker did mention that using that process, and as you noted, that his concern was that it was too short because of the 6 month with the 6 months. So you noted that correctly, that was an issue that Shane Baker brought up.
Right, and I think it was back in about 2010 or 11 that the 6 months was extended to 12 months. And I'm suggesting that we should extend it to 18, hearing that it takes 18 months to complete sex offender treatment appropriately. So I think that is absolutely critical, though we add that to the list of things that we do. It seems like the state adjudication process and the redemption process essentially is what they're trying to do, is very helpful. And probably if we do nothing else, that would be incredibly powerful for juveniles in particular.
Yep, and we'll get that to Shane to get further response from the county attorneys.
Right, and anything that we could do to make sure that every county is aware of it and is using that process. I don't know what we need to do legislatively, if anything, to do that, but maybe they can just do their trainings through the association. I don't know.
Renee.
Yeah, I would just say, Representative O'Neill, I definitely support that. During all of my years of supervision, I saw less than a handful come through on a stay of adjudication. It was very appropriate, but I also identified others that it would have been appropriate for also. So it would be interesting to see what the county attorney would say to that, because after you receive the psychosexual and you learn more about the individual, it can be pretty apparent sometimes, I'll say, because sometimes when they get into treatment, they reveal more. But I would definitely support that and say that that's appropriate. Stacy, I'm looking to you. Would it be presumptuous of our subgroup to come up with offboarding and what that would consist of and the criteria for that? Or should we wait for more of the research to come back, possibly on what the other states are doing? And then make a suggestion on the panel to get that conversation going. But again, I don't want to be presumptuous if you think that this is too early to do this.
Well, I'll just respond to that, and then I put a note to the group because I need to go off to this other thing. I think there's the states that the small group of states I looked at, they have really clear, solid things that would be required to bring forth a petition. And then I've seen a lot of the clear and convincing evidence as the standard for granting the petition, and that could be for the panel. But I think there's enough. I think that's the easier question, like what's in the petition, or who, what are the petition contents, and what are certain minimum standards that need to be met before you even get to write a petition. So I would say we just move forward on that. There's the questions that would benefit from the law clerks are more like which crimes, statutory, offenses, that sort of thing. I think that's where a law clerk could be helpful, and we can put together our heads in the sub to figure out what areas need more research, if you guys are okay with that. Yeah. Okay, I'm gonna pull off, and I just put the note to the group. So thank you, everyone, and we'll be in touch.
Patty.
Thank you, Renee, for moving that forward. That's what I would like to see. I think that, we could research forever, but we're going to design what works in Minnesota. And I think that gives us more firm place of discussion. So I would love to see that work in progress. Thank you.
Representative O'Neill.
Thanks. So Stacy had said in the chat too that she really wants to know how often law enforcement uses the POR to solve crimes. I think that is a huge question that will be asked at the legislature. I think Josh is maybe with us with the BCA, and I know he had talked about it at one point, and maybe he could address that since he works so closely with that. But yeah, so and maybe also if we're going to be asking county attorneys and law enforcement about the off ramp, we could also ask them the prevalence of actually solving crimes with the POR and not just accessing it to update information.
Representative O'Neill's Josh speaking. I've reiterated before, we at the BCA for sure, and anybody who's investigating sex crimes uses the registry a lot. My agents access it looking for suspects or confirming addresses or vehicles or secondary addresses weekly, if not daily. So I find it very helpful. You know, we do a lot of things where we maybe have a suspect and we sometimes go on there, and if the person's on the registry who we think is a suspect, it really helps us hone in on that person, and you can see some of the previous crimes they've done, and it helps in that way as well. So I think it's an invaluable tool, and we use it daily. So that's anybody who's investigating sex crimes as their main assignment seems to use it a lot.
Angie.
Yeah, I was just gonna say, I think we talked about this before, to really get that information, I think that would be something that would take a lot of time and money and, going to each individual agency, finding out what each individual agency does. And I really think, given the time constraints here, that it's really, and I think Patty sort of got at this, but it's kind of going to be more of a policy argument than saying, this is exactly how many times it's used for different things. I think the recommendations and I think the legislature's action is going to be some based on, the factors we've been able to see or the information we've been able to get. But I think, a lot of it's going to be based on what, from a policy standpoint, what the state thinks is appropriate for registration.
Representative O'Neill.
Thanks. No, I wasn't really asking for like a statewide survey. I know that that's extensive and probably unnecessary. Just having Josh explain, because he's obviously working with agencies all over the state. That's what they do.
Yep.
That's incredibly helpful. And literally just what he just said would satisfy me in a committee that this is still a valuable tool. They do use it daily. That's all I needed to hear. It's just that we haven't had it spoken quite so clearly. I think Josh alluded to that in the past. That's why I wanted him to be more specific. I've asked people out here in Wright County how often they use the POR to solve crimes, and I got a very vague, unhelpful answer. And so I'm digging deeper, and I'm going to actually go and talk to some of their investigators, as opposed to the person that follows up with offenders in Wright County. So I want to talk to the sex crimes investigators next, but I think what Josh said was that would satisfy the legislature to know that, no, it's a valuable tool. We're glad we built it. We use it daily. That's sufficient. I don't need a deep dive.
And I think I was more referring to Stacy's saying she'd like to discuss getting a data request to access the registry 6 million times in 10 years. I just think that's something that is not going to happen in this working group at this time. And it's something that's going to take a lot more time and resources if the legislature is really interested in having that information to make decisions.
Yeah, Angie, I would completely agree with you. And now that I read it more closely, that is what it says. So I'll just let you know that when we're, I've been on public safety almost 10 years, the committee and judiciary for about half of that. So I'll tell you, whatever Josh just said is sufficient for us to know that it's a valuable tool for law enforcement, and we want the right people on it. So I think we don't need a deep dive. We don't need the data.
Patty?
Am I unmuted? No, yes.
Yeah.
I agree. I totally agree that it's an invaluable tool for law enforcement. But I also want to state that growing the number of people on the registry doesn't necessarily make it a better tool. There are some people who have earned their way. They have turned their lives around, and it's been 20 years and they're still on the registry, and now they're married and have successfully done everything that was required of them. And so if it's an interest of public safety, it's a tool to make the safeties more communities safer and a tool for law enforcement. I think we have to make it the best tool possible. That's why, to me, getting the off ramp for those who have done what was asked of them and are trying to rebuild their lives is a really important part of honing the tool. I'm not suggesting to take it away from law enforcement. I know the value because we lived it. So I just think let's make it the best tool possible and clear those that have turned their lives around, giving them an opportunity to not beyond that. It's like it's more of an encumbrance to have it be bigger than we need as well. That's just my thoughts.
Anything else on this? Representative O'Neill.
Sorry, I'm rather chatty today. Probably because we're talking about nuts and bolts of actual legislation, and that's where I care a lot. I think, so back to the panel conversation and the focus. The focus really needs to be on making sure that person is no longer a risk to the public. If there's one thing that we need to hone in on, is that to make sure, whether you're doing assessments or you've got testimony from people, you've got demonstration in their life, whatever that is. But that's the most important thing to the legislature, is that if we're going to take someone off the POR, that they are not a risk to the public. So kind of regardless of whatever they had done in the past, that isn't as relevant. The most relevant thing is the risk level that they pose. And I know that's complicated because we have nearly 10,000 that are unassigned, and one would think that they are lower risk. That is not actually the case. And so I know at one point we talked about maybe unassigned level 1, level 2, whatever it was, as an input, but whatever the input is, the output needs to be that the public will be more safe.
Sorry, I can't raise my hand, but this is Katie. Brian, in the subgroup, did you guys talk about, I know it was mentioned, like the risk assessment, and the whole panel kind of sounds a lot like the equivalent of the ECRC hearing, and just maybe a different lateral position in there. But you had said that, or somebody had said they do basically some of that same assessments on the group for this off-ramping. Was it talked about then that, like, let's say you had a guy that was released from prison 8 years ago and had a risk assessment done then, would they get another one done to kind of hone in on Representative O'Neill's comment about make sure that there is no longer a risk there? Was it talked about that you would redo those risk assessments again closer to that off-ramping time?
Yeah, really what we did is modeled it based on we have a reassessment process for ECRC. There's some criteria that need to be met by the individuals that are levels 2 or 3 that want to try to get that. They want to get it reduced, of course, but we call it a reassessment. And so, yeah, there's an interview that happens with the individual. They meet certain criteria, having been, in the community. It's 3 years after their ECRC. They can't have any revocations or restructures within that time. They can't have no negative law enforcement contact. Pretty stringent criteria that most of them need to meet. And then we do an interview. We write a new risk assessment recommendation based on current information, current scores, current, protective factors, risk factors, what's going on with them now. So yeah, it wouldn't be based on anything 8 years when they got out of prison. It would be all updated information. We can do that same type of thing with probation cases as well. There's risk assessments that can be done. Doesn't need to involve somebody that's released from prison. You know, psychosexual is an essentially risk assessment with actuarials, and a full-blown risk assessment are done all the time. And then even if a guy ends up on probation, so we can do a similar process no matter risk level or not on the guy or gal.
Perfect, thank you. I was just thinking kind of about like what with the MSOP guys and how this, you know, your 244.052 had to get adjusted because the assessments were releasing them out of the facility as one basically doing that assessment, but they hadn't been out in the community really. So I just wanted to make sure that that was a point that they would be you know, the risk assessment basically redone just like every other offender if that's what the group decides to do. Thank you.
Yeah, and I think there was that earlier discussion, and Representative O'Neill brought that up about who would be targeted for this off-ramp. That would be those designated as the lower risk, the level ones, or those on probation who are also considered lower risk. That
Right.
when we're doing the risk assessment and somebody is designated as a 3 or 2, I don't think there was any idea that they're ready to come off the registry. If they're
Right,
still
but then we
considered a
also
2 or 3.
Sure, and I also want people to keep in mind our out-of-state offenders. You know, many, and Brian and Mark both know that many of them are not requested by law enforcement to be reviewed, and their crimes here, and if they went through that same proper channel, may be assigned a higher risk. I don't think that should be in question by anybody on this group. So just some food for thought on those.
Okay, anything else? Angie, once again, you get to be the one at the closing as the, oh, you're still on mute, Angie, there.
Sorry, I know, I haven't been, I've been shutting myself off so as not to constantly jump in with my pearls of wisdom. I don't have anything else, and we'll talk, as we said at the chairs meeting, about what I have a form to fill out for a law clerk, so we'll figure out what exactly we want the law clerk to do, and I'll get that. I told the supervising attorney I'd get that to them on Monday.
And we do want to give an opportunity if there are any public members in attendance before we close shop today. Were there any outside comments? If you do, please raise your hand. I don't think I see anybody at this point, so. Anything else? So to kind of wrap up, we're going to delve more into details, at least for this subgroup, work on that. And keep in mind that next week we don't have the subgroup, and the following week is the last scheduled subgroup meeting. That can change, but for now, the plan was to cancel next week's subgroup meeting, only again have it at bi-weekly, and then we'd have one more at least on the schedule. So
we'll also discuss that at the co-chairs meeting.
Yeah.
As far as if there's going to be anything added.
Okay. Representative O'Neill.
Thanks, real quick. So Brian, when you were talking about coming up with sort of who's eligible for to be considered, and you had said level ones, but we have nearly 10,000 unassigned. Would you also then put them through the process to be leveled or to be evaluated so that they would be the equivalent of a level 1?
Well, I don't know if it would be a formal, community notification process unless that whole thing was changed to include probationers, right? But we could look at probationers and maybe not designate level 1, 2, 3, but just lower risk folks based on actuarial scores, just doing an overall risk assessment. You can sort of categorize people into that lower risk category without assigning them an actual risk level. So I think it would be, if we saw a probationer that was scoring high on actuarial instruments and had other high risk factors and very few protective factors going on, that would be a guy I think the panel would say not ready to be off ramped. We're going to go through that whole process. If a guy shows he's doing really well and scores are low and he's got some stability and things like that, maybe that's a guy that we're looking at more. So real individual basis, and just a real thorough overall assessment.
Right. I guess my question is, to even qualify to apply, we had talked about one of the qualifications being assigned a level of risk 1, but we have nearly 10,000 unassigned. And so again, law, we need clarification.
Sure.
So to be eligible to be considered by the panel, not actually when you're before the panel, we need to say something about the unassigned since they don't have an official leveling. So that's something that needs to be considered.
Okay, and yeah, we can, Stacy and Renee can talk about that in the subgroup, or we could talk about it as a subgroup or the larger group too, and just, really hone in on what sort of criteria we're talking about for sure. Get that detailed for you. Yeah,
Okay.
definitely.
Great. Yep, that's going to be imperative because we need to know what the input's going to be. It's fine
Sure.
once they get before the panel, but to even qualify to apply, that needs to be crystal clear. Otherwise, you're going to have conceivably 10,000 unassigned people apply because you've said, well, unassigned, but you need to have a more narrow input. Go ahead.
Yeah, I was just going to say, I think Stacy mentioned that too in terms of the content, and a lot of the states are using petitions, but if we use an administrative process, still having that criteria detailed for sure. And I know Olivia mentioned that, and what's this, Mark mentioned it, what's it all going to look like? We'll get that, delve into the minutia and get that figured out for sure.
Right, which is why I was saying, like, I don't know what the process is to receive a level. I mean, I realize that unassigned or unassigned for a reason because they haven't gone through that process, and is that more of a DOC process?
Well, they're only subject to community notification, folks that are released from incarceration.
Yeah.
For the most part, it's going to be a prison, not in every case, but most of the guys with risk levels are released from incarceration and subject to registration. The folks that remain in the community as have committed an offense, an adult offense, or registering based on an adult offense and remain in the community are not subject to community notification. So that's what we're talking about, that group of guys for the most part. There's also juveniles, folks that were adjudicated delinquent as juveniles and maybe now are adults and released from prison, but their registration is based solely on the juvenile adjudication still. They are not subject to community notification either. So that's also in that unassigned group. It's either probationers or people that are released from prison solely on the basis of that juvenile registration.
And also those that are coming here from out of state. That's a whole other group of people.
And we look at that individually, and maybe Katie can speak to this too, but they have to have, the BCA has to, look at the information along with Angie usually to determine if registration is required based on, similar offense, and there's some detailed work there. And then if they determine registration is required, they have to have been released from confinement in that other state subsequent to that requirement for registration. So that's what we determine then moving forward with our ECRC process for out of state. Most of the out of state folks that are subject to the interstate compact, it gets more complicated with people that come here not under supervision. There's another piece to that, but I don't think it's super relevant right now. Anything to add, Katie? I don't know.
No, I think you got all of that covered. I agree with what you were saying on that. I just want to ask, from my understanding now is that all of this is basically based on what a risk assessment or something similar to that would assign to an offender. Is there any thoughts on any consideration as to what their record looks like? I mean, what if you've got the guy with 2, 3, 4 convictions Um, Is that not going to factor in at all on this group? Our largest number of offenders are assigned of risk level 1. Okay. And then we've got our almost 10,000 offenders who are not assigned. Are we looking at 10,000, 12,000? I mean, that's a lot. That could potentially be a lot of people eligible for this off-ramping. But if they have multiple sex offense convictions, does that push through and allow them to be part of this off-ramping? Are we looking at anything as far as number of convictions or what type of convictions? Or is that done through the ECRC equivalent, that assessment?
Brian,
I don't know if we've hit on that specific criteria yet, but it would seem to me a guy you're talking about with 4 or 5 convictions, especially if there was interventions in between those convictions, somebody who just keeps reoffending, that to me is going to be a really high risk person. The scores on the actuarials are usually going to bear that out as well, place them into that higher risk category. For sure, there's definitely subset of individuals that will remain high risk, that we want to keep on the registry, that could be valuable for law enforcement in future sex crimes where there is an unknown perpetrator. I agree with all of that. It's really, and I don't know the numbers of the most are on the lower risk end, but once we figure out that criteria, maybe we'd get a better idea of then what kind of numbers we'd be looking at. And then from a fiscal note, employment, staffing, this whole process, how that would look. I mean, we have 5 people doing end of confinement review committee right now. That's not going to suffice for an additional, however many thousand or whatever this applies to. So the nuts and bolts and the monetary stuff and the staffing would all, come legislatively later, I guess. But we'll still hone in on the criteria. Yeah, Katie, for sure that those types of individuals would still be a concern. And
right. Well, even, the 4 to 5 is one thing too, but even, that second offender, the second offense, is that enough to say, that maybe they are not allowed to petition? Or is, I just hope that people think that on that piece of it too, not just the risk level, because we know the people come out of the DOC with the risk level 1 and they could have multiple, court files and multiple victims and such. So are they going to still be eligible with multiple court files and victims? And, is there going to be some consideration as to that? How many different cases and how many more victims until it stops? So.
Yeah, I would think I was just going to add, Brian, thank you for putting more context around the probation piece, because of course that's what I'm advocating for this off ramping. So, but you did that very nicely. Thank you, Brian. I'm also thinking that someone that's on probation that has offended once and then reoffends even a second time, when there's an intervention that's occurring, I'm inclined to think that person's going to go to prison at that point. If they are offered an opportunity to continue to participate in treatment, then yes, I think the other thing we haven't talked about is what length of time in between successful completion of probation, so to say, should we wait for that reassessment to be completed. So, we had some out there that were 10 years, some were 15 years. So that is yet something that we haven't discussed the specifics of the criteria yet.
hey, anything else there? Lots of homework.
Need that law clerk in here, Angie. I want to do a lot of homework.
Okay, so are we good to wrap it up for today? You still have opportunity. Seems every little extra piece adds to the good questions that are coming up. Okay. Let's wrap this up for today then. Thank you for your time. Any last question or last information, Olivia? Okay, and Angie, anything? Okay, have a good day then.